Dunmore County, Georgia. Property tax is the most intimate form of taxation the government administers because it is levied not on income, which is abstract and variable, but on home, which is the specific and physical place where a person lives and sleeps and raises children and grows old, and whose value for tax purposes is determined not by the homeowner but by a county official called an assessor, who visits or is supposed to visit and applies a methodology or is supposed to apply a methodology and produces a number that becomes the basis of an annual bill that the homeowner must pay or risk losing the place that the bill is about. In Dunmore County, that official had been, for 28 years, a man named Hector Brand, whose official title was County Property Tax Assessor and whose unofficial role as the investigation that began in the spring of 2021 would establish was the architect of a systematic scheme by which the assessed values of properties into specific census tracts, both located in the county's historically black neighborhoods, had been inflated far beyond market value for decades, generating tax bills the homeowners could not afford to pay, triggering tax sales that extinguished their ownership rights, and transferring the properties into a network of limited liability companies whose beneficial ownership traced through 3 levels of corporate structure directly back to Hector Brand. The investigation was initiated not by a law enforcement agency and not by a journalist and not by a whistleblower inside the assessor's office, but by a newly elected county assessor named Vivian Marsh, who won the position in the November 2020 election on a platform that included, as one of 11 specific policy commitments, a comprehensive audit of assessment accuracy across all property classes in the county, a commitment she had made because 2 of the 3 neighborhoods she had canvassed most heavily during the campaign had residents who kept telling her, without a framework to explain why, but with a consistency she found impossible to dismiss, that their tax bills felt wrong. She had no technical training in property assessment at the time she made the commitment, which is why she had framed it as an audit rather than a correction, understanding that identifying the problem was a necessary precondition to addressing it. She was not prepared when she took office in January of 2021 and began the audit she had promised for the specific shape of what the audit would find. Vivian Marsh had been a social worker in Dunmore County for 15 years before running for office, work that had given her an intimate and detailed knowledge of the county's geography of disadvantage, the way certain neighborhoods had been excluded from the public investments that had changed the character of the rest of the county over the previous 2 decades, the way the same addresses appeared again and again in the family crisis files, the way the instability of housing tenure ran through those cases as a recurring thread even when the presenting problem was something else. She had not, in 15 years of social work, connected that housing instability to a specific mechanism. She had attributed it to the ordinary forces that produce housing instability, income stagnation, credit access limitations, the accumulated effects of historical disinvestment. She had been right that those forces were operating. She had not known that an additional force was also operating, one that was not the ordinary accumulation of structural disadvantage, but a specific human decision made by a specific human being in the county assessor's office. The audit. Vivian hired a consulting firm specializing in mass appraisal methodology in February of 2021 and gave them access to the full assessment records going back to 2005, the earliest year for which the office had fully digitized data. The consulting firm's standard methodology was to compare assessed values against recent arm's-length sales in the same census tract, using sales as the market evidence against which to calibrate assessment accuracy, a process that produces what assessors call a sales ratio, the ratio of assessed value to actual sale price, which should, in a well-functioning assessment system, cluster around 1 across all property classes and geographies without systematic deviation. Neighborhood deviations from 1 in either direction indicate either overassessment or underassessment of a systematic deviation correlated with neighborhood demographics is the signature of an assessment system that is not applying its methodology uniformly. The Dunmore County audit produced results that the consulting firm's lead analyst described in a preliminary report delivered to Vivian Marsh 6 weeks into the engagement as the most significant systematic deviation from assessment uniformity she had encountered in 22 years of mass appraisal work. Properties in the 2 census tracts the campaign canvassing had flagged, tracts designated in the county's own geographic information system as Northside and Millbrook, showed a sales ratio averaging 1.64 across the 15-year period, meaning that properties in those areas were being assessed at 64% above their actual market value on average. A deviation that could not be explained by any legitimate methodological variation and that was stable across the entire period, meaning it was not a recent error but a durable and consistent pattern applied year after year by the same office under the same official. The rest of the county's residential properties showed a sales ratio of 1.02 across the same period, a figure representing the ordinary small variance of a competently administered assessment program. The contrast between 1.02 in the white majority neighborhoods of Dunmore County and 1.64 in the 2 historically black census tracts was not the signature of incompetence. It was the signature of design. Vivian Marsh called the Georgia Department of Revenue's Local Taxation Oversight Division and the Dunmore County District Attorney's Office on the same afternoon in March of 2021, having read the preliminary report the previous evening and spent the night determining what she thought the appropriate next steps were. The DA's office assigned an investigator the following day. The Department of Revenue assigned a technical specialist within the week. The investigation had its formal opening date in April of 2021. Hector Brand, the outgoing assessor, who had retired from the position in January of 2021 after 28 years, was 69 years old, living in a house on the east side of Dunmore that he had purchased in 2003. He had been, during his tenure, a figure of routine visibility in county government, attending commission meetings, presenting the annual assessment roll without notable controversy, managing a staff of 7 appraisers whose work he supervised and whose individual case files he reviewed. Before certification, he was not, by any external account, a person who had raised flags. He served on the board of the county's United Way chapter. He had been recognized by the Georgia Association of Assessing Officials in 2011 with an award for assessment administration, an award whose criteria focused on technical accuracy and process management, and that the Association's current executive director, when asked about it in 2022, declined to comment on specifically and said only that the Association's awards had since been updated to incorporate external audit verification components. The financial investigation, conducted jointly by the DA's office and a forensic accounting team retained by the Department of Revenue, took 7 months to produce a complete picture. Because the corporate structure through which Brand had acquired properties from the tax sales was constructed with a care that reflected either legal advice or prior research into how beneficial ownership was traced. The 3 LLCs in the structure were managed by different registered agents in different states, held their assets in overlapping combinations, and had been formed at different points across a 12-year period, creating a layering effect that the forensic accountants described as consistent with intentional obfuscation rather than the ordinary corporate structuring that a legitimate real estate investor might use. The thread that ultimately tied all 3 entities to Hector Brand was not a direct ownership record but a property management contract signed in 2012 between one of the LLCs and a property management company that contained, in its signature block, a cell phone number whose subscriber record resolved to Hector Brand. The number was also the number Brand had given as his personal contact to the county's own assessor's office human resources department. He had used his personal cell phone number in a contract meant to be at arm's length from him, a lapse in the scheme's operational security that the investigating attorney described as the kind of mistake a person makes after 10 years of confidence that nobody is looking, when the confidence that nobody is looking has begun to feel like proof that nobody ever will. The properties. The investigation identified 47 properties that had been transferred through tax sales from their original owners to one of the 3 LLCs in the 15-year period of the scheme. In each case, the sequence was the same. A property in Northside or Millbrook received an assessment significantly above its market value, generating a tax bill the owner could not pay. A tax lien was filed. The property went to a tax sale after the statutory notice period, and an LLC purchased it at the sale for the amount of the back taxes owed, typically a fraction of the property's actual market value, then either held the property as a rental or resold it at market rates through a conventional real estate transaction with no visible connection to the LLC structure. The profit on the 47 properties, calculated by the forensic accountants against the acquisition prices at tax sale and the subsequent rental income and resale prices, was approximately $2.3 million across 15 years, a figure that the lead accountant noted was modest by the standards of real estate fraud in absolute terms, but was significant in the context of a scheme whose primary cost was borne not in money but in the displacement of 47 families from their homes. Of the 47 families, the investigation team's victim outreach effort was able to locate and contact 31 in the spring of 2022, the remaining 16 being either deceased or outside the investigative team's ability to reach through the available contact information. Of the 31 contacted, 24 agreed to give statements. Those statements formed a record that the DAW used extensively in the public case documents, not because the statements contained evidence of the scheme's mechanics, which the financial and assessment records established independently, but because they established what the mechanics had cost, which was the question the financial records could not answer. The statements were not all the same because the 47 families were not all the same, and their situations had not all been the same, and the ways in which the tax sale had changed their lives had not all been the same. But they shared a structure that was distinct from the ordinary story of financial hardship, because in each case the hardship had begun not with an income loss or a medical bill or any of the usual precipitating events, but with a tax bill officially issued by the county government that the homeowner had been unable to pay and had initially attributed their own failure to having mismanaged their money or failed to save enough or missed something they should have caught, and who had, in most cases, carried that self-attribution for years before the investigation told them that the bill had been wrong, that the assessment producing it had been wrong, that the wrongness had been deliberate, and that the person responsible for the deliberate wrongness was the same person whose official role had been, for 28 years, to get it right. Estelle Morrow. The most extensively documented of the statements came from a woman named Estelle Morrow, who was 73 years old when the investigative team reached her and who had, in 2014, lost the house on Meridian Street in Northside that her parents had purchased in 1962 and that she had lived in continuously since their death in 1989. Estelle had retired from her position as a school cafeteria manager in 2011 at 63 on a fixed income that was not large but that had been, as long as the house was paid off, sufficient for her needs without the mortgage payment that would have made it insufficient. The house was paid off. The property tax in 2012 had been $640 a number she had paid easily. The property tax bill in 2013 had been $1,420. Estelle had called the assessor's office to ask why. She was told that the assessment had been updated to reflect current market conditions in the area. She asked if the market had changed that much. She was told that it had. She paid the bill with difficulty. The 2014 bill had been $1,890. Estelle could not pay it. She had tried. She had applied for a homestead exemption that she did not, on review of the records, qualify for on technical grounds. She had applied for a payment plan and been offered one whose terms she accepted and then missed when a dental emergency in August of 2014 consumed the money she had set aside for the October installment. The lien was filed in November. The tax sale occurred in February of 2015. The LLC that purchased her house paid $4,200 at the sale, the amount of back taxes owed. The house was assessed for tax purposes at $112,000. Its actual market value at the time of the sale was approximately $85,000. Estelle moved into her daughter's house in March of 2015 and has lived there since, in a small bedroom at the back that her daughter had converted from a storage room and that Estelle describes in the statement she gave the investigative team not as inadequate but as not hers, a distinction that she made carefully and without self-pity, because she is a careful woman and because the distinction matters to her in a way that requires precision. The house on Meridian Street was hers. Her parents had bought it when the neighborhood did not have paved roads and the county did not provide trash collection to Northside, and the assessed values of the properties there were systematically undervalued because the county government of 1960 did not believe those properties were worth as much as they were. The generation that followed corrected that undervaluation by overcorrecting in the opposite direction. Estelle Morrow, who had lived in the house that her parents bought during one era of official misrepresentation of property values in Northside, lost it during another. Neither era has been asked to explain the other to her, which is not because the investigators and prosecutors and civil attorneys involved in the Hector Brand case have been indifferent to that continuity, but because the law they are working within does not have a mechanism for addressing it, and the mechanism it does have was built for a specific and bounded wrong rather than for the long and specific history that produced the conditions in which that wrong could be done this easily and sustained this long. The civil litigation on behalf of Estelle Morrow and the other identified victims of the scheme was filed in Dunmore County Superior Court in November of 2020 by a law firm specializing in property rights and civil rights law that had been tracking the criminal investigation since its public announcement. The civil case asserted, in addition to the standard wrongful conduct claims, a fair housing theory arguing that the systematic assessment inflation in the two historically black census tracts constituted a discriminatory housing practice under federal law regardless of whether Brand had been motivated explicitly by racial animus, because its effect was demonstrably and disproportionately homeowners in a community with a documented history of racially differential property administration. The theory was legally contested. It was also, in the view of the law firm's lead partner, the most important theory in the case, because if sustained it would provide a basis for relief, including possible property restoration, that the criminal conviction alone could not generate. The criminal case. Hector Brand was indicted in September of 2021 on 47 counts of theft by conversion, 1 for each property acquired through the scheme, 16 counts of falsification of official records, and 1 count of criminal conspiracy. He was arrested at his home on the east side of Dunmore and released on bond the same day. His attorney issued a statement describing the charges as a politically motivated mischaracterization of a career of dedicated public service by an incoming official pursuing a partisan agenda, a framing that received coverage in the local newspaper and that the people of Northside and Millbrook received with a silence that contained, depending on which resident you asked, varying proportions of anger, exhaustion, and the specific weariness of people who have been told versions of that sentence by various officials for longer than they have had legal standing to respond to it. The trial lasted 3 weeks in the spring of 2023. The prosecution presented the assessment records, the sales ratio analysis, the corporate structure, and the cell phone number in the property management contract, alongside the testimony of minus one of the homeowners who had given statements to the investigative team and who agreed to testify in person. The defense challenged the forensic methodology used to establish the sales ratio pattern, arguing that the comparison properties used to establish market value were not sufficiently similar to the assessed properties and that the deviation from uniformity reflected legitimate professional judgment rather than deliberate inflation. The expert witness the defense retained to support this argument was cross-examined at length on the specific assessments of 6 properties where the deviation from market value exceeded 90% and declined under that examination to characterize those specific assessments with any standard of professional practice he was aware of. The jury convicted on 41 of the 47 theft counts, the 6 acquittals reflecting cases where the connection between the assessment and the tax sale was complicated by intervening events, and on all 16 falsification counts and the conspiracy count. Brand was sentenced in July of 2023 to 19 years in state prison, with the sentencing judge noting in her remarks that the scheme's duration, its deliberate targeting of a community with limited resources to challenge its effects, and the specificity of the harm it had caused to 47 families made the length of the sentence appropriate, and that the court was limited by the applicable criminal statutes to addressing the criminal dimension of what the evidence described, and that the civil proceedings would need to address what the criminal proceeding could not. Brand did not speak at sentencing. His attorney did not request leniency. The gallery contained families from Northside and Millbrook who had driven to the courthouse and sat through the trial and the verdict and the sentencing in an arrangement of attention that the court staff described as the most sustained presence of community members they had observed in a criminal proceeding in the county. Did not tell him he was right. Vivian Marsh, did not tell him he was wrong. The woman who had run for office on a promise to audit the assessment records and had found in those records something she had not anticipated and had not been required to do anything with, but had done everything with, continued to serve as Dunmore County's property tax assessor after the investigation closed, running the office she had inherited from the man she had helped send to prison with a staff that had, over the course of the investigation, shrunk by 2 members who resigned and grown by 3 new hires whose selection she oversaw personally with the specific attention of someone who understood precisely what the person sitting in the assessor's chair could do with the authority the chair carries. She implemented, in the first year of the post-Brand administration, a set of assessment uniformity reporting requirements that the County Commission adopted formally in March of 2022 after she presented the audit findings in a public meeting that was attended by more Dunmore County residents than any commission meeting in a decade. The requirements included an annual independent sales ratio analysis by census tract, published publicly on the county's website, and a mandatory explanation of any deviation greater than 10% from the county-wide average to be submitted to the commission and made available for public comment before the annual assessment roll was certified. They also included a conflict of interest disclosure requirement for the assessor and all appraisal staff prohibiting any financial interest in properties subject to county assessment, a requirement that did not previously exist in the county's code and whose absence Vivian described to the commission in the public meeting as a gap in the county's ethical framework that the preceding 28 years had demonstrated was not theoretical. Those requirements will not prevent every Hector brand. They will make the next Hector brand scheme produce numbers that flag in an annual sales ratio report within 2 or 3 years rather than operating undetected for -1, which is different from prevention and better than what existed before, and which is the realistic standard for governance reforms produced in response to specific harms rather than imagined ones. The specific harm in Dunmore County had been done for 28 years and had produced a record that the new requirements would have caught within the first reporting cycle, which is not comfort for the 47 families and is not intended to be. It is an accounting of the gap between when the wrong thing started and when the mechanism to find it was put in place, a gap whose width in Dunmore County was 2 decades and whose contents were 47 homes and the lives organized around them and the people who organized those lives and who are still here, living in their daughter's back bedroom or in a rental in the county's other neighborhoods or wherever the displacement deposited them, paying rent where they once paid taxes, carrying what there is to carry in a county where the assessor now publishes the numbers publicly every year so that anyone who wants to look at them can look at them, which is the minimum and which is new. Estelle Morrow did not attend the sentencing hearing. She told the Victim Services Coordinator that she had given her statement and that the statement was in the record and that the record would do what the record did, and that attending the sentencing was not something she felt she owed the case or the court or herself. She was at her daughter's house on the morning of the sentencing, in the small bedroom at the back that is not hers, and she said later that she had not thought much about what was happening in the courtroom, that she had done the breakfast dishes and then sat for a while in the backyard, where her daughter had a garden that is not the garden Estelle kept on Meridian Street, but that is a garden and that is hers to sit in. And that she had sat there in the July morning until the heat came up and then gone inside, and that was what the morning of the sentencing was for her, which was a morning, and which was hers, and which was in a yard in Dunmore County that is not on Meridian Street, and that she is not in any legal sense required to leave. The house on Meridian Street was purchased from the LLC that held it in November of 2022 as part of the civil settlement negotiations by the Dunmore County Housing Authority at a price reflecting its current market value and is being held pending the outcome of the civil litigation in a dedicated account as a potential remediation asset. Estelle Morrow's attorneys have argued that the property should be returned to her. The LLC's attorneys have argued that the tax sale was legally valid under Georgia, willing to carry, and regardless of the assessor's misconduct without ceremony and the chain of title cannot be particular moment of decision to set down and leave where they left ruled. The house on Meridian Street is occupied by tenants who have been informed of the pending litigation and who have a lease that runs through the end of The year. The Estelle Moreau who bought a house in 1962 could not have imagined the specific sequence of events that would produce the Estelle Moreau sitting in her daughter's backyard in 2023 waiting for a court to decide whether she can go home. The sequence was not natural. It was made one assessment at a time by a man in a county office who understood that the number he wrote on a form would determine whether the person the form was about could stay in the place that the form described, and who wrote the number he wrote anyway for 28 years, because nobody was looking at the ratio, and because the people most affected by the ratio had the fewest resources to challenge it, and because the gap between what the number should have been and what it was had been for 28 years nobody's responsibility to measure until a social worker ran for office on a promise she intended to keep and inherited a set of assessment records that told her, in a ratio, what 28 years of a man's private arithmetic had done to the people of Northside and Millbrook, one house at a time, from an office where the authority to determine value and the motivation to misuse it had been, for the entire length of her predecessor's tenure, the same man. The county assessor's office on Commerce Street now publishes its sales ratio analysis on the first business day of each December. The most recent report shows a county-wide residential assessment ratio of 1.03, with a range across census tracts of 0.98 to 1.08, a distribution that the consulting firm's lead analyst, reviewing it as part of her ongoing contract with the county, described as representing accurate and uniform assessment administration. Northside is at 1.01. Millbrook is at 0.99. The numbers are in the public record where anyone can read them. They are the right numbers. They have been the right numbers for 3 years. The record of when they were not is also public and also in the record and will remain there alongside the right numbers for as long as both sets of records are kept, which is the minimum the county owes the people. The wrong numbers were written about, and which is, in Dunmore County in 2024. What there is. The appraisers, who did not know. Among the staff Vivian Marsh inherited when she took office in January of 2021, were 4 appraisers who had worked under Hector Brand for periods ranging from 6 to 19 years, people who had spent their professional careers in the assessor's office. Applying the valuation methodology Brand directed them to apply without, as the investigation eventually confirmed, having reason to suspect that the methodology they were applying in Northside and Millbrook differed from the methodology they were applying everywhere else in the county. The systematic inflation was not visible at the individual case level because Brand had structured the review process so that the Northside and Millbrook properties were assessed by different appraisers in different cycles, with Brand himself reviewing and certifying the results, and because the inflation was applied at the review stage rather than the appraisal stage, meaning that the number the appraiser submitted was often close to market and the number the certificate bore after Brand's review was higher, a discrepancy that was absorbed into the certification process without anyone below Brand's level seeing the before and after comparison. 2 of the 4 inherited appraisers resigned voluntarily in the months following the audit report's public release, both citing a need to process what they had been part of without knowing they were part of it, a statement that Vivian received with what she later described as a complicated mix of professional respect for their honesty and genuine uncertainty about the correct response to people whose complicity was structural rather than intentional. The 2 who stayed did so after conversations with Vivian that she has described as some of the most difficult of her professional life conversations, in which she tried to distinguish, with as much precision as she could manage, between culpability and proximity between the person who designed the system and the people who operated it, in good faith, and to establish, for herself as much as for them, that the distinction was real and that it mattered for purposes of going forward together in a repaired office, and that holding both truths at once, the truth that they had not known and the truth that the work product they had produced had been used in the way it was used, was the work the office is now trying to close with varying resources had to do before varying urgency and the shared. The two appraisers have remained. The office has produced 3 years of accurate and uniform assessment records under their new reporting requirements. The consulting firm's analyst, who knew them only as the names attached to the case files she reviewed in the original audit, has said that the quality of their work in the post-brand period is indistinguishable from best practice appraisal work in any county in Georgia, which is a statement about their professional competence, and also, she has acknowledged a statement that raises a question about how a competent professional produces work that is used to harm the people it is supposed to serve. A question that she does not think has a clean answer, but that the Dunmore County case has required her to think about more carefully than her standard audit methodology had previously required, which is one of the things that cases like this one do to the people who are close enough to the record to see it whole. They produce questions that the record answers and questions that the record makes more complex and questions that the record simply holds open without resolution as the permanent remainder of what the investigation could establish and the ordinary human accounting of what it could not. The neighborhood, Northside and Millbrook were, before the assessment scheme and during it and after it, neighborhoods of modest houses on streets with modest names, neighborhoods whose character was shaped by the same forces that shaped every historically Black neighborhood in the Georgia Piedmont. The specific history of where Black families were permitted to buy property in the decades after formal segregation, the accumulated underinvestment of governments that had other priorities, particular social density of communities that had developed over generations, a practice of mutual support that was partly a response to exclusion from other forms of support and partly a culture in its own right, worth something independent of the conditions that produced it. The houses on Meridian Street and on the surrounding blocks were not large or ornate. They were owned, many of them, by people who had saved for decades to own them, or who had inherited them from parents who had saved for decades, and who organized their financial lives around the ownership in the way that homeowners organize their financial lives, which is with the assumption that the place is stable, that the county government's relationship to their address is at minimum neutral, and that the piece of paper in the county's records that says the house is theirs means what pieces of paper from county governments are supposed to mean. 47 of those assumptions had been wrong, not because the legal system had malfunctioned in the ordinary way that legal systems malfunction, but because a specific man in a specific office had decided that the assumptions of the people in those 47 houses were an exploitable resource, that the gap between what they believed the county's records said about their homes and what the county's records actually said about their homes was a gap that he could widen invisibly year by year and fill with money in a county where the people most likely to notice the widening were also the people least likely to have the resources to challenge what they noticed, which turned out to be the most important thing he knew about the people of Northside and Millbrook, and the thing he was most wrong about not because those resources materialized as he had assumed they would not, but because the person who eventually found the wrong number was not a lawyer or an auditor or a state official, but a social worker who had spent 15 years in those neighborhoods and had run for an office she had not previously held because the people she knew there had told her something felt wrong, and who had, upon taking that office, simply done what she said she was going to do, which was look at the numbers, and which had produced the specific and unrepeatable sequence of events whose outcome is this record, in this county, in these streets, where the assessments are now accurate and the ratio is public, and the man who wrote the wrong number for 28 years is in prison in Georgia, and the person who found the wrong number is still in the assessor's office on Commerce Street, publishing the right number on the first business day of every December. The numbers are in the public record. The record is open. The county owes it to the people of Northside and Millbrook to keep it open and to keep getting the number right, which is not a complicated obligation.
Without resolution, which
is not a new one, and is
conflict,
exactly what the office was supposed
is different from acceptance
to be doing all along,
from the outside.
and which is what it is doing now. And
Nadine Prater still lives in the house on
which
Claiborne
is
Road
in the
where she and Roy.
specific history of these two neighborhoods in this county. In
She told
this
a reporter
state,
in the summer
not
of 2023
nothing, and
that
not
she didn't
enough,
think of
and all that is immediately available. What the
And
people who are still here are working with and will continue working with for as long as it takes to determine whether all that is immediately available is what there is, or whether there is more, which is what the civil litigation is trying to find out in the slow and specific way that the legal system finds things out one motion at a time in a courthouse, in a county where the assessor's office on Commerce Street is publishing the right number and the house on Meridian Street is waiting for a court to decide who it belongs to, and Estelle Morrow is in a backyard that is hers to sit in, doing what she does in the mornings when the heat is not yet up. The law professor's analysis among the academic responses to the Dunmore County case, the one that received the most attention in the property tax policy community, was a law review article published in the Georgia Law Review in the spring of 2023 by a University of Georgia property law professor named David Achebe, whose research specialty was the intersection of property tax administration and racial wealth inequality, and who had, over 15 years of academic work, developed a theoretical framework for understanding systematic assessment bias that the Rand case illustrated with a specificity and a completeness that his theoretical work had not previously had access to. The article was 42 pages long, carefully footnoted, and addressed in its first paragraph the question that Achebe said had been raised for him, personally, by reading the Dunmore County Audit Report, which was whether what had happened in Northside and Millbrook was an exceptional case of individual criminal opportunism or a concentrated and visible example of a pattern of assessment administration that existed across many jurisdictions in the American South, and that was not criminal in most of them because it had not reached the specific threshold of individual profit-seeking that Brandt's team represented, but that was producing similar effects through the ordinary operation of assessment discretion applied unequally across racial lines. His answer, documented across 42 pages of case analysis and comparative data from 14 Georgia counties and 11 additional counties in Alabama, Mississippi, and Tennessee, pattern was neither rare nor exceptional. That systematic overassessment of Black majority neighborhoods in the same county was documentable in a majority of the counties he reviewed, and that the Brandt scheme was distinguished from the ordinary pattern not by its existence but by its beneficiary. because the profits of ordinary systematic overassessment in those counties accrued not to an individual official, but to the county governments. General fund through higher tax revenues and the properties that were lost through tax. Sales entered the ordinary real estate market rather than a specifically constructed corporate structure, outcomes that were worse in aggregate for the affected communities and less visible in their causation than what Brand had done, and that were consequently less likely to produce the sequence of events, the audit, the investigation, the conviction that the Brand case had produced. The article concluded with a policy argument for mandatory public sales ratio analysis by census tract in every Georgia county, a requirement that did not yet exist in state law and that Achebe argued would, if implemented, make the kind of systematic BAAs he had documented in 14 counties visible enough to require official response even in cases where no individual official had profited directly from it. The Georgia legislature had not, as of this account's compilation, adopted the requirement. The bill had been introduced and had received committee hearings. Vivian Marsh testified in support of it. Her testimony lasted 17 minutes and included a description of what the sales ratio had shown in Dunmore County and what it had cost, and a statement that the requirement she was supporting would have produced a flagged report in Dunmore County. In 2008, 13 years before she took office and began the audit she had promised, which would have been 13 years before Estelle Morrow lost her house and -1 years before 46 other families lost theirs, and which would have required a public explanation from Hector Brand at a time when Brand was still in office and still had a cell phone number in a property management contract and still had a private server in a closet with a piece of furniture in front of it, and that requiring that explanation would not have made him honestly explain the scheme, but would have made the scheme more difficult to continue without detection, which is the most realistic thing a reporting
Identity
requirement
is built
can accomplish,
around.
and which is, in the context of what the 13 years without the requirement had cost, worth saying clearly and on the record in front of the people who have the authority to require it. The committee took her testimony. The bill is pending. The sales ratio data for 14 counties in Georgia is in the academic record, available to anyone who reads the Georgia Law Review. The assessment records for Dunmore County are public. The criminal record is public. The civil litigation is ongoing. The house on Meridian Street is waiting. Estelle Morrow is in a backyard that is hers to sit in, and the morning heat is not yet up. And what happens next is what the courts and the legislature and the county commission and the consulting firm and the two appraisers who stayed and the assessor who ran for office on a promise to look at the numbers will collectively produce in the ordinary and imperfect and not yet complete way that things are produced in a county trying to account after the fact. And with the tools available for 28 years of a man who understood exactly what his authority could do and did it quietly and specifically and without detection, until a social worker looked at a ratio that nobody had required anyone to look at before and found that the ratio, when you looked at it, said something that the county government of Dunmore County needed to hear, and that some of the people who needed to hear it are still here to hear it. And some of them are not, and the record contains both. The assessor's office on Commerce Street is open 5 days a week. The sales ratio analysis for the current year is on the county website. The number for Northside is 1.01. The number for Millbrook is 0.99. Those are the right numbers. That is where this account ends, with the right numbers, which is both more and less than where it needed to end, and which is what there is. To end with, and which is, in Dunmore County in 2024, what being right? Looks like after 28 years of the wrong thing, which is quiet and public. And small on the screen, and exactly what it was always supposed to be. The 5 families who could not be reached. The victim outreach effort, which located and contacted 31 of the 47 identified families, spent 6 months attempting to locate the remaining 16 and was ultimately unable to establish contact with all but 2 of them. The reasons varied across the 16. Death of the property's former owner with no identified surviving family members, out-of-state relocation whose destination records were not findable with resources, and, in 3 cases, a specific and deliberate unavailability communicated through a relative who passed on the message that the family did not want to be contacted in connection with this matter. The last category, the deliberate unavailability, was not explained by any of the intermediaries who passed on the message, and the investigative team's victim assistance coordinator respected it without pressing further, because the decision about whether to participate in an investigation into a harm done to you is yours to make and no one else's, and because the people who had made that decision had already given the most important thing the investigation needed from them, which was not their testimony but their existence in the record as people to whom something was done, a fact established by the assessment records and the tax sale records and the corporate acquisition records without requiring their participation. The 2 families the outreach effort did locate after extended search, both of whom had relocated out of state, chose not to give formal statements but asked the victim assistance coordinator, through their respective attorneys, to be kept informed of the proceedings. They were kept informed. They were present, through their attorneys, at the sentencing. Neither family attended in person. Their presence in the record is a flag on a case file in the DA's office that says notified, and the flag is there, and the presence it. Records is real, and what they do with the knowledge the investigation gave them is theirs to decide in whatever time and whatever way their specific lives and their specific losses and their specific distances from Dunmore County make possible for them. What happened to the money? The $2.3 million in profits that the forensic accountants calculated from Brand's scheme was the focus of the asset forfeiture proceedings that ran parallel to
the
criminal case from the time of the arrest. The 3 LLC structures held, at the time of Brand's arrest, assets consisting of 11 properties still in their portfolio, approximately $400,000 in liquid accounts, and a set of receivables from ongoing rental arrangements. The criminal court's forfeiture order, issued after the conviction in conjunction with the sentencing, directed the liquidation of the LLC assets and their transfer into a court-managed restitution fund, whose disposition was then determined through a separate civil proceeding in which the attorneys for the identified victim families negotiated the distribution formula against the AG's office oversight of the forfeiture process. The total amount available in the restitution fund after liquidation, legal fees, and administrative costs was approximately $1.7 million. Divided across 47 families, the average distribution was approximately $36,000 that the attorneys for the families describe as representing a fraction of the actual economic harm in most cases, and a figure nonetheless, and that the families received, individually and differently, as the thing it was, which was money in the place of a house, which is not the same and which was available and which was taken. Estelle Morrow received $36,000 and put it in an account she has not touched because she is waiting to see what the court decides about the house on Meridian Street, and because the $36,000 is not what she wants from the case, and because what she wants from the case is the thing that $36,000 cannot buy. which is the house her parents bought in 1962 in a neighborhood where the county government thought their property was worth less than it was, and which she lived in for 53 years, and which she lost because a different county government decided it was worth more than it was, for reasons that had nothing to do with the house and everything to do with what the house represented to a man who had the authority to write a number on a form and the motivation to write the wrong one. She is still waiting. The court has not yet ruled. The house is on Meridian Street. The account has $36,000 in it. The assessor's office on Commerce Street is publishing the right number. The morning heat is coming up in the backyard at her daughter's house. She is there. She is waiting. The record contains all of this and will hold it as long as records are kept, which in Dunmore County's court system is the duration of the appeal period plus 25 years for civil matters and permanently for criminal ones, which means the wrong number and the right number will coexist in the official archive of this county for longer than anyone now alive will live to see a permanence. That is the record's way of saying that what was done here was done, and that what was found here was found, and that the gap between those two events, which was 28 years and 47 houses, and the specific lives organized around those houses, is not going to be smoothed over by time or by administrative reorganization or by the quiet normalization that follows scandal once the cameras move on, because the record will be there after the cameras are gone, and anyone who needs to see the gap can find it in the archive on Commerce Street in the county that finally looked at the ratio and found it was 1.64 when it should have been 1, and did what you do when you find the wrong number, which is say so, and follow it, and put it in the record, and let the record be read. The morning the verdict came, the jury in state of Georgia v. Hector Brand returned its verdict on a Thursday morning in May of 2023, after 4 days of deliberation. The courtroom was full. The gallery was arranged roughly as it had been throughout the trial, with representatives of the identified victim families on one side and Brand's supporters, who had diminished in number as the trial progressed from roughly 30 people on the first day to 8 on the day of the verdict on the other. Vivian Marsh sat in the gallery rather than the counsel table because she was a witness rather than a party, and she had testified in the second week and had been released from the witness exclusion order and had attended every subsequent day because she wanted the record to contain her presence in the room when it reached its conclusion, not for any legal purpose, but for the reason that any person who has spent 2 years building a case for what happened in a place they are responsible for wants to be in the room when the room reaches its verdict. The verdict was read aloud by the foreperson. She stays for about an hour and then drives home, and she read each count in a clear and even voice, and the word guilty repeated 41 times for the theft counts and 16 times for the falsification counts, and once for the conspiracy count, accumulated in the courtroom the way verdicts accumulate, count by count, until the number is too large to hold in the imagination as a number and becomes instead a shape, the shape of 28 years measured in counts, each count a property, each property a family, each family a set of years and decisions and savings, and the specific and irreplaceable thing that owning a house where your parents owned a house means to a person who has organize their understanding of stability around that specific continuity. When the foreperson finished reading, the courtroom was quiet for a moment that lasted roughly 4 seconds by the clock on the wall and considerably longer by every other measure available. Vivian Marsh had said that she did not cry and did not feel relief. That what she felt was more like a settling, a quality of things being in the place where they were supposed to be, which is a different experience from happiness and a different experience from justice, but something she has not found a more precise word for and has stopped trying to find because the feeling was its own thing and does not require a name to have been real. She drove home after the sentencing hearing and sat in her own house, which she owns, in a neighborhood where the assessment ratio is 1.03. And she thought about Estelle Morrow and the $36,000 in the untouched account and the house on Meridian Street and the court that had not yet ruled, and she thought about the 47 counts and the 19 years and the sales ratio on the county website that shows 1.01 for Northside and 0.99 for Millbrook, and she sat with all of it together in the way that the person most responsible for a record sits with the record when it is as complete as she was able to make it, which is imperfectly and with the specific knowledge of everything the record contains and everything it does not, and what the record does not contain is what she goes to work every December to put in it, which is the right number, published publicly 1 year at a time for as long as she holds the office and for as long after that as whoever holds it next understands what the number is for and what the record that holds it is for, which is not bureaucracy and not procedure and not the ordinary administration of a county function, but the thing that all official records are ultimately for, which is accountability, which is the knowledge that the number can be checked and that the checking matters and that the gap between what the number says and what the ground says is a gap that someone is looking at every year in the county, where for 28 years nobody was required to look. The office is open. The number is public. The record is complete and incomplete. Estelle Morrow is waiting. The morning he comes up